Today's hearing is Financial Services and the LGBTQ plus community. Hereinafter, I will simply say the community, a review of discrimination in lending and housing. Dear friends, this is a landmark hearing, and it is long overdue. And if there is one thing that I would have you take away from this hearing, especially those persons who are members of the community, it is this: you are not alone. You are not alone. You have allies in the Congress of the United States of America. There are people here who have suffered invidious discrimination, understand the implications of it, people who do not want to manage it, people who want to end it. You are not alone. I would also have you know that Dr. King was right when he reminded us that life is an inescapable network of mutuality tied to a single garment of destiny. What impacts one directly impacts all indirectly. He went on to say that I can't be all that I ought to be until you are all that you ought to be. And you can't be all that you ought to be until I'm all that I ought to be. You are not alone. We are in this together. And today, we have evidence, overwhelming evidence, that will show invidious discrimination that, quite frankly, until this hearing, I wasn't aware of. I would also remind you that the staff has done an outstanding job in compiling this information, and I'm honored to have the Honorable Maxine Waters, who has also indicated that she is supportive of this hearing. You are not alone. The evidence is going to show many things. And for the record, I am into my 5-minute dissertation, Mr. Ranking Member. The record will show many things. The record and the evidence will show that there is economic insecurity among the LGBTQ plus community. The record will show that the LGBTQ plus community experiences discrimination in housing and lending. The record will show a lack of legal protections for the community. In fact, the Supreme Court is considering a trilogy of cases that will decide whether federal laws prohibiting sex-based employment discrimination protect LGBTQ plus persons. The record will show that when it comes to mortgage lending, the discrimination exists and it is provable. When it comes to rentals, the discrimination exists and it is provable. And finally, the evidence is going to show that discrimination against the elderly LGBTQ persons exists as well. As I indicated, you are not alone. We are going to do all that we can to not only present evidence of this invidious discrimination, but we also want to have legislation to combat the discrimination. It is not enough for us to simply hold this hearing, present all of this empirical evidence, and then walk away assuming that we've done our jobs. We have to produce meaningful evidence that can produce tangible results. And if we should do this, we will have made a difference in the lives of not only the members of the community, but in the lives of all people within the country. Because this is broader than the community, it's really about humanity, and whether humanity will go forward together, recognizing that invidious discrimination is not something that we can tolerate. For edification purposes, these hearings do make a difference. Unrelated to this hearing, but as evidence of the fact that the hearings make a difference, I have a document. It is a publication, and it is styled Citicorp's Jane Frazier, in line to become the first female CEO of a major bank. This is in part because at a hearing, we had members of the major banks who were asked whether or not their successors would be a person of color, a member of the community, or a person who was a female. And the evidence that was displayed, the visual evidence, has had an impact. And it looks like we are moving in the right direction. So we hope that this hearing will produce similar results. With this said, I shall now yield 5 minutes to the ranking member for his opening statement.
Thank you, Chairman Green, for holding this hearing and for your continuing work to promote equality in financial services. I welcome our witnesses. I thank you all for being here. I think we can all agree that discrimination based on race, gender, or sexual orientation, or any other immutable characteristic is wrong and should not be tolerated anywhere, including in the mortgage and consumer lending industries. Unfortunately, despite federal and state laws prohibiting discrimination on those bases in financial services, some evidence suggests that LGBTQ citizens may still face disparate treatment in housing and consumer lending. Unfortunately, lenders' access to and reliance on data that is not demonstrable of creditworthiness, such as gender or race, may lead to subjective judgments that discriminate against certain populations. Lenders and landlords should rely more heavily on risk-based metrics for evaluating creditworthiness that are blind to demographics or immutable characteristics. Data-driven decisions could prevent discrimination or judgments that may be clouded by unintended biases, or intended biases for that matter. Credit reports do not utilize data on gender, sex at birth, sexual orientation, or race. They rely solely on metrics that reflect a borrower's credit history and ability to repay, such as a number of open lines of credit, balances due, payment history, and whether the borrower has filed for bankruptcy. Reliance on these metrics without consideration of race, color, religion, or sexual orientation can promote equality in financial services and guard against deliberate or unintended biases. Some of our witnesses today relied on data provided by lenders under the Home Mortgage Disclosure Act, or HMDA, for their research. Among other things, HMDA requires lenders to collect and report gender data on their borrowers. While this may be useful information, it has the potential to allow for biased underwriting. We need to ask ourselves, are data provided pursuant to HMDA doing more harm than good? Are there more effective ways to collect necessary information that could offset unintended biases? This is a conversation that I very much look forward to having with the chairman and other members of the committee as we work to close the gap of financial services in underserved populations. Research indicates that LGBTQ Americans utilize basic financial services, such as bank accounts and retirement plans, at a lower rate than the non-LGBTQ population. It should be a goal of this committee to expand access to financial products and services to all corners of the population, regardless of race, gender, sexual orientation, or whether they live in an urban or rural community. Expanding financial inclusion initiatives and improving financial literacy are critical to closing the gaps for and underbanked citizens in our country. In an age of economic prosperity, we should work to ensure that all citizens feel the benefits. And data-driven decision-making based on financial technology and innovation driven through free enterprise is very likely the best antidote to discrimination. Once again, I thank Chairman Green for holding this important hearing, and I thank the witnesses for being here today, and I'll yield the remainder of my time to the ranking member.
Well, I thank the ranking member, and I believe every citizen should have an equal opportunity for home ownership. We have important laws on the books, federal and state laws that prohibit discrimination. But as we'll hear from witnesses today, there are indications that discrimination based off gender identity and sexual orientation may be occurring. As it stands now, the Home Mortgage Disclosure Act, or HMDA, forces lenders to identify and report the gender of their borrowers. On one hand, HMDA provides a useful source of data, but on the other hand, the presence of gender information on mortgage applications may be contributing to discrimination in the first place. This hearing is important for us to understand what is happening in the real world and to change policy where necessary. I yield back.
The chair recognizes the gentlelady from California, the Honorable Maxine Waters, who is also the chairperson of the full committee, and she is recognized for 1 minute.
Thank you very much, Congressman Green, for holding this important hearing. Americans who identify as lesbian, gay, bisexual, transgender, or queer have long been subjected to discrimination while attempting to access quality education, employment, health care, housing, and basic financial services. Faced with such prolific injustice, LGBTQ plus individuals, especially LGBTQ plus persons of color, are more likely to experience economic insecurity than non-LGBT individuals. Alarmingly, the Trump administration has sought to gut federal regulations that guard against anti-LGBTQ plus discrimination in lending and housing. In May 2019, for example, HUD proposed changing its own rules to allow federally funded homeless shelters to deny admission to transgender individuals based on their gender identity. It is unacceptable that this administration is using taxpayer dollars to put already vulnerable Americans further at risk. I thank you, Mr. Chairman, and a question I will ask later on if I have the opportunity. I yield back.
General Leader yields back. Without objection, the chair is authorized to declare a recess of the subcommittee at any time. Also without objection, members of the committee who are not members of this subcommittee may participate in today's hearing for the purposes of making an opening statement and questioning witnesses. At this time, I'd like to welcome the witnesses, and I'm pleased to introduce the witnesses. We have today Harper Jean Tobin, Director of Policy, National Center for Transgender Equality; Michael Adams, CEO of SAGE; Karith Cornran, Research Director, Williams Institute, UCLA School of Law; Alfonso David, President, Human Rights Campaign; Ha Sun, Professor, Iowa State University; Francis Creighton, President and CEO, Consumer Data Industry Association. I welcome the witnesses and thank you for being here. The witnesses will be recognized for 5 minutes each to give an oral presentation of their testimony. Without objection, the witnesses' written statements will be made a part of the record. Once the witnesses finish their testimony, each member will have 5 minutes within which to ask questions. On your table are lights, 3 lights. Green means go, yellow means that you have 1 minute left, which means that you're running out of time and you should start to conclude your remarks. And the red light means that you're out of time. When the red light is visible, you will probably hear me give a light tapping, which will give you a further indication that you are out of time. With that, Ms. Tobin, you are recognized for 5 minutes for your opening statement.
Thank you, Chair Green, Ranking Member Barr, Chairwoman, Ranking Member of the full committee. Pleased to have you with us today, and members of the subcommittee and the full committee. My name is Harper Jean Tobin. I'm Director of Policy for the National Center for Transgender Equality, and I'm pleased to be able to testify for this historic hearing. Nearly 2 million transgender Americans live all across this country. And while being transgender need not and should not be a barrier to opportunity in the United States, transgender Americans today do face severe and widespread discrimination. In 2015, NCTE conducted the U.S. Transgender Survey with nearly 28,000 respondents in every state. We found a home ownership rate 1/4 that of the U.S. population. We found nearly 1 in 4 respondents had faced housing discrimination or housing instability as a result of being transgender in the past year alone. We found nearly 1 in 3 respondents had been homeless in their lives. More than 1 of 10 of them have been homeless in the past year alone. These rates were even higher among transgender people of color and those with disabilities. In the previous year, 7 in 10 transgender people seeking emergency shelter had faced discrimination there, including harassment, physical assault, or being turned away simply because they were transgender. And 1 in 4 respondents who had been homeless in the past year reported they didn't even try to seek shelter out of fear. Now, for nearly 20 years, federal courts have overwhelmingly held that laws such as the Fair Housing Act and the Equal Credit Opportunity Act prohibit anti-transgender discrimination. Unfortunately, the Trump Justice Department has rejected the majority view of the courts and urged the Supreme Court to strip those protections away. In 2012, independently of those laws, HUD adopted the Equal Access Rule, explicitly prohibiting discrimination in all HUD-funded programs. And in 2016, after further study, it added clarifying language to the rule, providing that individuals should be placed, served, and accommodated in accordance with their gender identity. Secretary Carson has repeatedly assured Congress he had no plans to roll back that rule, most recently on May 21st of this year. However, the very next day, HUD revealed that it in fact planned to do just that and had already sent a plan to do that to the Office of Management and Budget a month previously. The Secretary's explanation for misleading the Congress and this committee was essentially the same one the White House has given for its ban on transgender troops, which is to say we are against discrimination, but that turning transgender people away isn't discrimination, which is nonsense. HUD's proposal is inconsistent with authorizing statutes that direct it to ensure every person in the United States has access to decent shelter. It also conflicts with the Violence Against Women Act and the Fair Housing Act. Advocates for the homeless and for survivors of sexual and domestic violence were quick to condemn this heartless move, but HUD has seemingly doubled down. Last month, Secretary Carson shocked his own staff with an unprompted and demeaning anti-transgender tirade. While it's understandable that some people may have questions or concerns about how non-discrimination protections for transgender people work in practice, we don't have to imagine the answers to those questions. We already have them from decades of experience with hundreds of state and local laws, with 2 decades of federal case law, with several years of implementation of the HUD rule nationally and the parallel protections of VAWA, and from HUD's extensive past consultation with leaders and experts in the field. We need to address housing and lending discrimination against LGBTQ Americans and the high rates of homelessness among these communities. And to do that, Congress should act in several ways. First, to immediately block HUD from rolling back equal access protections, as this committee has already voted to do. And to stop other administration attacks on housing opportunities, such as the mixed immigrant status rule that would evict tens of thousands of children. This committee should demand answers and transparency from Secretary Carson about the process by which he developed his anti-transgender proposal. The Congress should clarify and strengthen our fair housing and lending laws by passing the Equality Act, as the House has already done. And finally, we need to make ambitious investments in ending homelessness in this country. And I know the chairwoman has introduced a bill that would get us some way towards those investments. These problems are grave, but they are not inevitable. By committing to equality and investing in opportunity, we can ensure all Americans have access to a decent home. Thank you.
Thank you for your testimony, Ms. Tobin. Mr. Adams, you're recognized for 5 minutes for an opening statement.
Thank you, Chair Green and Ranking Member Barr, for the opportunity to be here today on behalf of SAGE, the country's oldest and largest organization advocating on behalf of 3 million LGBT older adults. My goal today is to add to the committee's understanding of the causes as well as the costs of financial insecurity and housing discrimination, in particular as it impacts LGBT older people. Let me start by briefly sharing 2 stories of our LGBT elder pioneers. Like countless members of the LGBT community, Jay Toole, now 71, has stood up to a lifetime of ignorance, harassment, and danger simply for being who she is. At 13, Jay was forced to leave home because of her family's homophobia. At 20 and homeless, Jay witnessed the start of the Stonewall Uprising on June 28, 1969. 50 years later, and after a lifetime of community service, Jay now struggles to get by financially and also struggles mightily to find discrimination-free housing, which she can afford. As a boy, Jeremiah Newton realized that he was gay. He knew that he would have to fight for his place in the world. Jeremiah recently said, and I quote, "As a young gay man, I witnessed the first night of the Stonewall Rebellion. It's important to know that everybody who is LGBT, whether we are 15 or 100, has been through our own personal Stonewall. We've gone through something difficult. We've jumped over that wall to be free." Jay and Jeremiah's experiences touch on themes SAGE sees consistently across the LGBT elder population: economic insecurity and disproportionate susceptibility to financial scams and abuse. Many LGBT elders also face housing and employment discrimination and the cumulative impact of discrimination over the life course. As a result, LGBT older people are far more concerned than older Americans in general about their financial security as they age. Nationally, same-sex older couples have lagged significantly behind different-sex married households in income, assets, and home elders and for LGBT elders of color. Moreover, LGBT older people struggle with thin support networks and severe social isolation. For example, LGBT elders are 4 times less likely than older Americans in general to be parents and twice as likely to grow old single, a particular challenge given the crucial support that adult children and partners provide in old age. Partly because of this isolation, LGBT elders are even more susceptible to financial abuse than older Americans in general. Despite advances in legal protections, LGBT older people are one of the most underserved and at-risk populations among our nation's older adults, and this is even more true of subpopulations. For example, many LGBT older adults are living with HIV as they age, reflective of the fact that by 2020, 70% of Americans living with HIV will be 50 and over. Many LGBT Hispanic older people report that they suffer from multiple layers of discrimination and that they lack the community support they need. Older LGBT African Americans are at higher risk for serious health conditions like Alzheimer's and are less likely to have access to culturally competent care. Transgender elders are more likely to face social and geographic isolation, to be denied appropriate health care, and to struggle from financial insecurity. The challenges that LGBT older adults face manifest especially when it comes to housing. A 2014 10-state investigation found that 48% of same-sex older couples seeking senior rental housing experience discrimination. That's 48%. This data shows the pervasive challenges that older LGBT people face when trying to find housing. Yet despite these statistics and the many stories that we have to demonstrate the real harm that is done, in most states, LGBT elders are not explicitly protected from discrimination based on their sexual orientation and/or their gender identity. And as a result of rampant discrimination and the lack of legal protections, many LGBT elders are forced back into the closet as they age. The challenges that LGBT older people face are daunting. We at SAGE cannot address them alone. We yearn to once again look to the federal government as a partner to bring financial security and discrimination-free housing, care, and services to LGBT elders. Unfortunately, through its various anti-LGBT policy moves, the Trump administration presents a powerful impediment to the well-being of LGBT older adults rather than a source of support. We ask Congress to closely monitor the administration and to reverse those trends because our elders deserve the support of all Americans in all branches of our government. Thank you.
Thank you, Mr. Adams. Ms. Conran is now recognized for 5 minutes for an opening statement.
Thank you, Chairman Green, Ranking Member Barr, and Chairwoman Waters, and members of the Committee on Oversight and Investigations. Thank you for the opportunity to speak with you today about housing lending and the LGBTQ+ community, a population of 11 million LGBT adults and 2 million LGBT youth. My name is Kareth Conran. I'm the Research Director for UCLA School of Law's Williams Institute, a center that focuses on the impact of law and public policy on LGBTQ+ people. As a social epidemiologist, my research examines sexual orientation and gender identity-based differences in socioeconomic status, contributors to those differences, and the consequences of such differences. So a large body of research has found that LGBT people experience discrimination and harassment in housing, employment, and other domains of life. LGBT adults are twice as likely as non-LGBT people to report ever having been prevented from moving into or buying a house or apartment by a landlord or realtor. Controlled experiments funded by the U.S. Department of Housing and Urban Development found that same-sex couples and transgender individuals were less likely to receive responses about rental units and were shown fewer rental units than others. LGBT adults are more likely to report being fired or denied a job than non-LGBT adults. They're also more likely to report being denied a promotion or receiving a negative job evaluation than non-LGBT adults. And an extensive body of research shows that LGBT students, both in secondary school and emerging body of literature about discrimination and harassment among college students, shows that LGBT students are more likely to be bullied and otherwise victimized than non-LGBT students. And as Dr. Sun will describe, same-sex mortgage applicants are less likely to be approved than different-sex loan applicants. Discrimination contributes to homelessness and housing instability and lower rates of home ownership among LGBTQ+ people. These patterns have been observed in convenient sample studies for quite some time, but we're now at the point in the field where we have population-based representative studies that show the same patterns. We have experimental designs that show the same patterns, and we also have records from administrative complaints. So these patterns of discrimination are undeniable. In terms of homelessness and some statistics, LGBT youth and transgender adults are far more likely to be homeless and unstably housed than non-LGBT youth and adults. Recent analyses conducted with the TransPop data funded by NIH found that 30% of transgender adults reported that they had to move twice or more often in the prior 2 years, compared to only 11% of cisgender, and when I say that, I mean non-transgender people. LGBT adults are less likely to own homes and are more likely to rent than non-LGBT adults. We conducted analyses of data collected by the CDC across 35 states in preparation for this hearing and found that half of LGBT adults on average own their homes compared to about 70% of non-LGBT adults. Rates of home ownership are even lower for transgender adults at about 25%. Homelessness, housing instability, they dramatically increase the risk of violence victimization, exploitation, and poor health, and there's a literature to support this. What I've shared with you today relies upon the best available data, but gaps in existing federal data systems need to be filled. If questions about sexual orientation, gender identity, and assigned sex at birth were included in the American Community Survey and the American Housing Survey, then the committee could request information about home ownership, mortgages, housing and rental costs, and housing quality for LGBTQ+ communities directly from the Census Bureau. Similarly, if the Survey of Consumer Finances conducted by the Federal Reserve Board included similar questions, then information about credit usage and refusals, housing and educational loans, debts, and assets would also be available to the committee. Many surveys conducted by the census include information about the sex of married and cohabitating partners. And while that is very valuable and was radical to include in those surveys in 1990, which is the year that I graduated high school, and as you can see from my hair is now many decades past, we now know that only 80% of people who are LGBT are living in cohabitating households, which means that 20%, which means that we are missing data for about 80% of the LGBT adult population by not including questions about sexual orientation, gender identity, and assigned sex at birth in these surveys. So in summary, increasing access to affordable housing will mean prohibiting discrimination in employment, housing, education, lending, and public accommodations, as well as expanding federal data collection systems designed to monitor the public well-being. Thank you.
Thank you, Ms. Conran. Mr. David, you are now recognized for 5 minutes for your opening statement.
Thank you. Thank you, Chairman Green, Ranking Member Barr, and members of the committee. My name is Alfonso David. I am the president of the Human Rights Campaign, which is the nation's largest civil rights organization working to achieve equality for lesbian, gay, bisexual, transgender, and queer people. On behalf of our more than 3 million members and supporters, I appreciate the opportunity to appear at this hearing. Tonight, more than 10,000 LGBTQ young people do not have a safe place to sleep. In some United States cities, 30% of the homeless adult population is LGBTQ. The faces behind these numbers reflect that our community, the most vulnerable members of our community, are our youth, our transgender siblings, and people living with HIV. Our community faces discrimination and rejection in every area of life, at school, at work, and at home. Distressingly, the weight of this discrimination falls disproportionately on the shoulders of LGBTQ people who are racial minorities, specifically Black and brown members of our community. Black male couples are most likely type of family to experience discrimination when seeking rental housing. Transgender people feel these stark racial disparities even more acutely. Nearly 40% of Black transgender people have reported eviction and racial disparities because of their gender identity, and report rates of homelessness 3 times of that of white transgender people. Latinx, Native American, and multiracial transgender people report similarly significant higher rates of discrimination. Before law school, I volunteered at the Whitman Walker Clinic, the LGBT health center right here in Washington, D.C., working directly with people living with HIV to receive aid through federal programs. I have seen the impact of a lifetime of discrimination in the eyes of people who have met closed door after closed door. The epidemic of LGBTQ homelessness is a national crisis, and it demands a national response. Unfortunately, we have a president in the White House and a secretary of HUD who are just not ignoring us. They're weaponizing our nation and our programs against us. For the past decade, HUD has interpreted the Fair Housing Act to include protection for LGBTQ people. This interpretation is consistent with robust judicial trajectory determining that discrimination on the basis of sexual orientation and gender identity is unlawful sex discrimination under our nation's civil rights laws. These federal court decisions are not just novel outliers, but rather markers of the evolution of the judicial understanding of discrimination to more faithfully accomplish the mission of the underlying statutes. In fact, this is the law in half of the circuits in this country. Prioritizing ideology over law, the Trump Justice Department withdrew specific guidance regarding gender identity discrimination and has replaced it with a narrow and legally specious interpretation of Title VII that would exclude LGBT workers from its protection. Trump has promoted this retrograde interpretation in Supreme Court briefs in 3 cases this term that the court will determine whether Title VII actually protects LGBTQ people. The outcome of these cases will directly influence the interpretation of protections under similar civil rights statutes, including the Fair Housing Act. Secretary Carson has also narrowly interpreted the rules, and specifically rulemaking for equal access. This rule provides crucial protections from discrimination for LGBTQ people in HUD programs, including loans backed by the Federal Housing Authority, the FHA. Access to FHA loans are traditionally served as a critical tool to bridge opportunity gaps based on discrimination for chronically underserved populations like people who are low income, LGBT, and people of color. Although the equal access rule has been previously interpreted to protect people, LGBTQ people, unfortunately, this federal administration is taking a different tact. Secretary Carson's HUD has also placed a target on these regulations, and that has meant so much to people in the past. He has proposed replacing tested regulations with a vague laundry list that would allow emergency shelters, for example, to choose how or whether to serve transgender people. LGBT people listening to my testimony today face discrimination in almost every facet of their lives. And we need the federal administration to actually protect them, not to subject them to further discrimination. Thank you.
Thank you, Mr. David, for your testimony. Professor Sun, you're recognized for 5 minutes for your opening statement.
Thank you, Chairman Green, Ranking Member Barr, and committee members for giving me this opportunity to testify. My name is Hua Sun, and I'm an associate professor of finance at Iowa State University. I recently published a paper jointly with my co-author at PNAS that looks at the potential disparate lending practice to same-sex mortgage borrowers. We found that compared to different sex borrowers of similar profiles, same-sex borrowers are statistically more likely to be rejected when they apply for a loan. When approved, they pay higher interest rate or fees on average. And we are unable to find statistical evidence that same-sex borrowers are more risky to lenders than comparable heterosex borrowers. The primary data used in our loan underwriting analysis is a 20% random sample of the publicly available HMDA data between 1990 and 2015. It gives us over 30 million loan application records that involve both a borrower and a co-borrower. We use the mandatorily disclosed sex information to distinguish same-sex borrowers and heterosex borrowers. We then merge the HMDA data with the publicly available Fannie Mae single-family loan performance data on over 400,000 approved loans originated since 2004. And we use this merged data to check the financing cost and subsequent loan performance. Our findings show that, compared to heterosex borrowers with similar characteristics, same-sex borrowers experience about 3 to 8% lower approval rate. Further, among the loans that are approved, each year, lenders charge higher interest or fees to same-sex borrowers in a range between 2 to 20 basis points. Our inferred dollar value on the higher financing cost burdened by same-sex borrowers nationwide is equivalent to an annual total of up to $86 million. Yet, we fail to find any evidence that same-sex borrowers are more risky. Indeed, our data shows that same-sex borrowers are equally likely to default on a loan, but less likely to prepay for their mortgage. So, on average, there is some evidence that same-sex borrowers seem to be slightly less risky. As sexual orientation is not disclosed in the data, we calculate the correlation between our inferred same-sex population density and a 2015 Gallup LGBT population survey at the state level. We found that, depending on the measure used, the correlation is between 0.61 to 0.85. As another robustness check, and in order to rule out the possibility that a borrower and a co-borrower are relatives, we only look at same-sex borrowers that have different race. We continue to find significantly lower approval rate on this restricted sample of same-sex borrowers. One limitation on HMDA data is its lack of borrowers' information such as credit history. We cross-validate our findings of lower approval rate by using the data on the sample of borrowers in Boston metropolitan area in 1990. This data was collected by the Federal Reserve Bank of Boston. Previously, this Boston-based data has been used by many researchers to study minority lending discrimination. The strength of this data is that it has very detailed information such as a borrower's credit history, working experience, educational backgrounds, etc. The Boston data reveals that after controlling for the borrower and mortgage characteristics, same-sex applicants are 73.12% more likely to be denied when they apply for a loan than different-sex borrowers. We also look at loan underwriting in time series and find that the lower approval rate to same-sex borrowers is quite persistent over time. Indeed, the HMDA data implies that the gap is even larger in 2015 than in 1990. In regard to lending practice on agency versus non-agency loans, we find that the largest gap is on conventional loans, where the gross approval rate to same-sex borrowers is about 7% lower than different-sex borrowers. The gap is about 4% on VA loans and about 0.8% on FHA loans. To summarize, our study documents some statistically and economically significant evidence on adverse lending outcomes to same-sex borrowers. The lending disparity appears to be throughout the life cycle, from applying to paying off a loan. Like any empirical research, our study is subject to limitations such as omitted variable bias. Having said that, I believe these findings are still concerning, given that the current credit protection laws, such as Fair Housing Act and Equal Credit Opportunity Act, do not explicitly list sexual orientation as a protection class. I wish our study and this testimony can help initiate a meaningful discussion on the need and the means to provide stronger protection to LGBT borrowers. Thank you very much.
Thank you for your testimony, Mr. David. Professor Sun, the chair now recognizes Mr. Creighton. You're recognized for 5 minutes.
Thank you for the opportunity to to appear before you today at this historic hearing on a very important issue. CDIA, my organization, promotes the responsible use of consumer data to help all consumers, regardless of age, race, gender identity, sexual orientation, or any other discriminatory qualifier, achieve their financial goals and to help businesses, governments, and volunteer organizations avoid fraud. Consumer reporting agencies are governed by many federal and state statutes, rules, and judicial opinions, but the touchstone of the laws that govern our industry is the Federal Fair Credit Reporting Act. According to the law's findings, Congress expressly sought to make sure the credit reporting system is fair for consumers, for all consumers. As a result of the FCRA and the hard work of our members and the entire credit reporting ecosystem, consumers today benefit from a democratic, accurate, and fair credit system. Consumers have the liberty to access credit anywhere in the country from a wide variety of lenders based solely on their own personal history of handling credit. If a consumer has been a responsible user of credit in the past, lenders and others are more likely to offer credit at the most favorable terms. Credit reporting companies and other CDIA members are helping solve the problem of the unbanked and underbanked by expanding the kinds of data collected, such as rental history or payments on telephone and other utility bills, giving lenders and others information that allow more consumers to responsibly access traditional financial services and integrate consumers into the mainstream financial system. And consumers are the main beneficiary of our credit reporting system. Most consumers pay their bills on time and are rewarded for doing so when they seek out new credit and their report shows a positive history. Without the credit reporting system, lenders would not be able to judge whether individuals applying for credit have previously paid their bills on time, and interest rates on loan products would have to increase for everyone to account for the added risk, with consumers who have been consistently paying bills on time losing out. Credit reports also give a variety of different kinds of lenders access to the same kind of information, giving a local community bank or credit union a chance to compete against a trillion-dollar financial institution. So as we begin this hearing, it's important to know what is and is not in a credit report. Credit reports do not include sexual orientation. Credit reports do not include gender identity or sex assigned at birth. Credit reports do not include marital status or spouse. They also do not contain data on race, color, religion, or national origin. Credit reports do include the following identifying information: name, address, date of birth, and social security number, which is only used as an identifier. For each account, credit reporting agencies maintain the creditor name, account type, account number, date opened, the credit line, the balance, and the payment history, and if an individual has had a bankruptcy in the last 10 years, that appears as well. One of the great benefits of our nation's competitive credit reporting system is that it delivers factual information which serves as a check against individual biases and assumptions. The reliable consumer report information provided by our members gives lenders and creditors the tools they need to fairly achieve the goal of equitable treatment for each consumer, while also contributing to safe and sound lending practices. Without this system, subjective judgments could be made even more on factors other than the facts of creditworthiness. Thank you for the opportunity to contribute to this hearing, and I look forward to your questions.
Thank you, Mr. Creighton, for your comments. The chair will now recognize the gentlelady from New York, Ms. Velasquez, for 5 minutes.
Thank you, Mr. Chairman. Mr. Adams, as you know, New York City's LGBTQ senior population struggles with substandard housing conditions, poverty, and homelessness, particularly in parts of Lower Manhattan that I represent. In fact, according to one study, nearly 1 in 4 of New York City's LGBTQ senior population was reported living in substandard housing. Can you speak to the unique challenges our LGBTQ seniors face, not only in New York, but across the country, and what recommendations do you have for addressing these issues?
Thank you for that important question. And to your point, I think what we see is a housing crisis that LGBTQ older adults face in New York City and across the nation for several fundamental reasons. One is extremely high levels of discrimination against LGBT older adults in housing. You know, as I mentioned in my testimony, we have a study from the Equal Rights Center conducted in 2014 that found that 48% of LGBT older adults who are applying for senior rental housing are subjected to discrimination in that process. Then what we see is for LGBT older folks who find housing, often they are subjected to harassment, discrimination, and mistreatment by their neighbors. This challenge is also exacerbated by the fact that we have substantially higher levels of poverty among LGBT older adults than older Americans in general.
Recommendations.
Yes, so in terms of recommendations, first and foremost, we need to pass the Equality Act, which would prohibit discrimination in housing against folks who are LGBT. This is fundamental. Eliminating discrimination is critical. Second, we need to ensure that there is support for LGBT-friendly elder housing developments. In New York City, as you mentioned, there are 2 LGBT-friendly affordable housing developments that are in construction now. There are a number of them across the country. We have to substantially increase the number of those. And third, I would say that we need policies that encourage and mandate training for housing providers to ensure that they do not engage in discrimination and that they provide culturally competent housing to LGBT older adults. Thank you for the question.
Professor Sun, your research study found significant and costly discrimination in mortgage lending to LGBTQ borrowers, with same-sex borrowers facing lower approval rates and higher interest fees than different-sex borrowers. First, can you explain your findings? And second, what impact do these lending patterns have on the financial security of same-sex couples and the lifestyle choices they make?
So according to our study, same-sex borrowers on average experience about 3 to 8% lower approval rate, which implies that the homeowner rate for same-sex couples is likely to be lower in a similar range. And also, conditional on their loan is approved, they pay a higher interest rate or fees, so their effective interest rate is about 2 to 20 basis points higher than the heterosex borrowers. So we inferred that nationwide, the annual actual premium charge to same-sex borrowers is somewhere between $8.6 million to $86 million.
Thank you. Professor, earlier this year, I introduced H.R. 963, Professor Sun, the Home Loan Quality Transparency Act of 2019, which reinstated Dodd-Frank's expanded HMDA reporting requirements that were stripped out last year as part of the passage of S. 2155. Senator Cortez Masto has introduced companion legislation on the Senate. Can you talk about the importance of HMDA's reporting requirements and how, without HMDA finding and prosecuting discriminatory lending practices, will be far less effective?
First of all, I do want to point out that HMDA data is very crucial when we try to examine the disparate lending practice to like same-sex borrowers or minority borrowers. However, using mortgage data can be misleading if our purpose is to study the more general demographic patterns of LGBT people in general. Having said that, in the HMDA data, right now the biggest limitation of the HMDA data is that it does not have a lot of mortgage characteristics, information like loan-to-value ratio, debt-to-income ratio, and it does not have a lot of information about the borrower, such as the borrower's credit score, working histories, age, etc. That will make our, as an empirical researcher, that makes it very difficult for us to draw any like a causal impact or potential disparate lending practice to this group.
I gather that you will be supportive of my legislation.
The gentlelady's time has expired long since. You may answer. You may respond. The question was, would you support her legislation?
Definitely.
The gentlelady yields back.
Thank you. I yield back.
Chair now recognizes the gentleman from Florida, Mr. Posey, for 5 minutes.
Thank you, Chairman Green, for holding this hearing today. I believe Americans want a fair financial system where access to credit and mortgage finance is determined by credit worthiness and absolutely free from bias that has nothing to do with the person's ability to repay the loans they seek. That's a principle that I supported in all the considerations we hear before this committee, and perhaps the best way to ensure that our financial system is unbiased is to ensure that the information that supports the decisions are free from bias. I'm pleased that we have here today Mr. Creighton, the CEO of the Consumer Data Industry Association, that represents the credit reporting agencies that provide the information I have in mind here. Mr. Creighton, I had the opportunity to look at the report by Dr. Ann Schneer entitled Credit Bureaus in the Digital Age, Recommendations for Policymakers. It was released by the CDIA. I commend your efforts to focus attention on consistent and integrated standards and regulations for credit reporting. The study makes some interesting observations about the benefits of credit bureaus. One of those benefits is ensuring credit availability and economic resiliency by giving lenders the information they need to assess the risk of potential new borrowers and to design and price products to meet the needs of previously underserved populations. Focusing on the last part of that, can you share with us how good credit bureau data helps to design and price products to meet the needs of the previously underserved?
Yeah, thank you for that question, Congressman. There's really two areas that I would mention as part of this. One is the continued exploration by our members in trying to get non-traditional data into credit reporting. Things like rental income, rental data, are you paying your rent on time every month? Utility data, are you paying your gas bill and your electric bill? These aren't traditionally thought of as credit accounts, right? But if you're paying your bill every month on time for 10 years, that should be an indicator that, in fact, you're going to be able to pay your credit bills on time later. And so that expands the credit group of people who can get access to credit, because you have a population that right now isn't being served because they don't have a traditional credit card or something else. So when they need a financial product, they can't go to a bank or somewhere else because they have a thin file or no file. So that's one way. Another way is by doing something called trended data. So instead of just looking at a credit report in just a snapshot moment of your credit history, where are you right now, by using something called trended data, we're able to look back over time and to see how all of your credit accounts are moving. So for example, if you have a spike in your credit at this moment, but it's explainable because of other things in the past, that can be incorporated into the score.
Good. Thank you, Mr. Creighton. Is the information provided through credit bureaus completely free of the kind of information that might enable the discrimination we're hearing about today in this committee?
Yes, it is. And that's not to say that there isn't discrimination in the entire system, right? All what we're able to say is that it's not being provided at this point in the process by the consumer reporting system. Okay. As I said in my opening statement, we just don't have this data, and we wouldn't want to collect it.
Okay, thank you. We've had several hearings on perceived bias in financial institutions based on membership in various groups of the population. I'm always puzzled that competition among lenders doesn't simply drive out discrimination of that nature. There are lots of alternative lenders in the market. Do you believe that market competition is or can be an effective force in reducing or eliminating bias in lending?
Sure, absolutely. If there's a market that's not being served because of discrimination, I believe that other lenders will likely come in and take advantage of that and provide products and services to that group. I don't represent lenders, so I can't say specifically, but sure, that does make a lot of sense.
Can you think of any examples offhand?
Well, I think about some of in the small business space, what's going on in fintech right now, and how the fintech companies are in there kind of offering new financing tools to people in the small business space that otherwise those communities weren't getting served. Relatively small dollar loans. That's one example of where.
Well, that's good to hear that the market can actually change processes like that. I see my time has expired, Mr. Chairman. I yield back. Thank you.
Gentleman yields back. The gentleman from Illinois, Mr. Caston, is recognized for 5 minutes.
Thank you, Mr. Chair. Thank you all so much for coming. I'm really struck by Mr. David's comments that 40% of homeless youth identify as LGBTQ, and if I understand right, I think a third of all transgender folks have experienced homelessness at some point in their life. For so many, the shelters are really the last refuge, and especially the government-funded shelters. And I am particularly concerned, in light of that, about some of the decisions that have been made in light of the Hobby Lobby decision to essentially legally allow discrimination as long as we wrap it up in some kind of a religious theory. Want to start with and in particular, there's been two recent decisions: the Department of Housing and Urban Development draft rule that would allow shelters to house people while considering the shelter administrators' quote religious beliefs and the individual's sex as reflected on official government documents. And then also in August 14th of this year, a Department of Labor draft rule that essentially just used the Hobby Lobby to justify hiring, which, at least as I read it, would affect government housing and decisions that are made there. Ms. Tobin, is there any evidence that allowing transgender people into homeless shelters conforming with their gender identity poses a risk to other residents?
No, there is none.
What about for the broader LGBT community?
No, there is none. And in fact, we have, as I said, decades of experience across the country that what protections like the Equal Access Rule result in is simply that some people who didn't have the opportunity before have the opportunity to come out of the cold and be connected with shelter and ultimately with permanent housing.
Is there any evidence that forcing transgender people onto the streets or into shelters that don't conform with their gender identity causes harm to themselves or others?
Of course. The whole reason we invest in emergency shelter is because we want people to be safe, to be healthy, to be able to connect with permanent housing. And it doesn't make any sense to cut a large portion of the population out from those programs when Congress has directed HUD to ensure that every American has access to decent shelter.
So would you describe a decision to refuse shelter to a member of the LGBTQ community as merciful?
I would not. You know, there's nothing more important to most faith traditions than loving your neighbor and serving people in need. And there are scores of faith-based organizations around the country, from San Diego to Boise to programs that Covenant House runs across the country that serve transgender people in accordance with their gender identity every day. And we know that there are some who, for various reasons, refuse to serve our community. And we respect everyone's beliefs, but ultimately, HUD taxpayer funds are first and foremost for serving everyone in need.
So, you're familiar with the Sermon on the Mount?
Yes, Congressman.
Would you care to comment on how one can justify a decision to discriminate based on a book that blesses the merciful, the meek, the persecuted, and the peacemakers?
Well, sir, I'm certainly not here to take issue with anyone's theology, but I would hope that we can all agree that, as I said, the foundations of most faith traditions are serving people in need. Most faith-based organizations see no issue with complying with these non-discrimination rules. And again, first and foremost, our taxpayer funds are to serve everyone who is in need. And that should really be the deciding factor.
Thank you. I yield back.
The gentleman yields back. Ordinarily, the chair would recognize someone from the other side. However, given that we've been informed that there are no further persons to question from the other side, the gentlewoman from Pennsylvania, Ms. Dean, is recognized for 5 minutes.
Thank you, Mr. Chairman, and I'm pleased to be a part of this historic hearing. Thank you to all the testifiers for your expertise and bringing us important information. Maybe I would like to start with Dr. Conran. In your testimony, you write that homelessness and housing instability dramatically increase the risk of victim violence, victimization, exploitation, poor health, incredibly grave circumstances for the community. Could you highlight highlight some of the data and the statistics that you are citing?
Sure. When people don't have stable places to stay, they're in circumstances where they are on the street, where they are subject to increased risk of violence victimization, and or they are at risk of needing to exchange sex for a place to stay. And when people engage in sex work, they are at increased risk of STI infection, HIV infection, violence. They are increased risk of being picked up by the police and then further victimized by the police and being charged with sex work crimes. We see an overrepresentation of LGBT people in the criminal justice system. We see an overrepresentation of people, LGBT people who are poor, food insecure, particularly bisexual, transgender people, and LGBT people of color communities. And so it's really this systematic, pervasive pattern of stigma and discrimination that elevates risk for vulnerability at lots of points in the life course, and particularly for youth, and particularly for transgender adults.
Thank you very much. Mr. David, in your testimony, and it has been talked about here, 40% of homeless youth identify as members of the community. I'm also lucky to serve on the Diversity and Inclusion Roundtable subcommittee. And so this summer we held Diversity and Inclusion Roundtables, one in particular on LGBTQ individuals. During that event, a leader of the PA Youth Congress described working with a college student who was being evicted because his same-sex partner, also a caretaker because the student has MS, was not on the original lease. Given that kind of consequence, can you talk about others similarly situated in that kind of discrimination?
Sure. Unfortunately, we're seeing across this country LGBT people being targeted for discrimination, not only in terms of lending practices, but also mortgages and rentals as well. And unfortunately, because we don't have comprehensive protections that are on the state level, and we certainly see that the federal protections are being challenged in the US Supreme Court, LGBT people are at risk of being discriminated against. The federal administration, unfortunately, as you know, has taken a position, the Trump administration, to advance regulations that would effectively enshrine discrimination into our regulations. And it further exacerbates a problem because LGBTQ people are facing discrimination every single day. A same-sex couple who is seeking to purchase an apartment in any part of this country may be discriminated against simply because they're LGBTQ. If they're racial minorities, it's even worse. And so we need to pass the Equality Act, and we also need to fight back against these regulations that are seeking to enshrine discrimination into our regs.
Thank you, and I want to stick with you, if I could, Mr. David. I share with you your grave concern over the course of this administration, and I was sitting here thinking about it. The pattern is always the same. Whether we're talking about anything from the environment to equality and everywhere in between, the Trump administration seeks to tear down protections, tear down the things that actually would make us more equal, would make us more safe, would protect our planet, as I said, and everywhere in between. They want to strip away protections. You began in your testimony to talk about how we could make a change. Number one, pass the Equality Act. What specifically do we need to do as policymakers?
We need to pass the Equality Act. I know the House of Representatives has already passed the act. We're waiting on the Senate to take action. And that bill would effectively provide protections, comprehensive protections on a national level. Right now, we have circuit court decisions for the past 2 decades that have concluded that LGBTQ people are indeed protected under Title VII. What many people don't know is that there is no federal public accommodation statute that would protect racial minorities, as an example. So if I went into a Gap department store to purchase a shirt, I could be discriminated against, and there is no federal protection based on race. There are state protections, but no federal protection. The Equality Act would fix that. And we also need to make sure that, as I said before, the equal access rule has been in place for years. there is no reason to modify the equal access rule. And modifying the equal access rule will have disproportionately negative impacts on LGBTQ people and racial minorities.
Thank you for helping us lift up the Equality Act. We were proud as members of this committee and the House.
Has expired.
Pass it. Thank you, Mr. Chairman.
The gentlewoman from Texas, Ms. Garcia, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you so much for this convening of a very important and historic hearing on this topic. I think it's a topic that's been of great concern for many of us, and certainly coming from Texas and being a leader against the fight, the Texas bathroom bill, we all know that at least I'm convinced that part of the reason that many people have some of these views and do discriminate is because they simply fear the unknown. Many of them that we talked to during those hearings had never even sat down and visited with anyone that was transgender. They had not even met anyone that was transgender. They didn't even know what it meant, hence the fear about the bathrooms. So I think it's moving in the right direction, but I wanted to get to the heart of it, because as Ms. Dean said, it's really about how do we protect the protections, if you will, and how do we move forward. And Mr. Adams, I was a geriatric social worker in one of my prior lives. And I remember going into a nursing home where there was an elderly person who was, quite frankly, in need of psychiatric mental counseling because they felt completely isolated because nobody wanted to be their roommate. It was back in the day where, especially in Medicaid-funded facilities, you always have to have someone in the room, and it was two to a room because the person was gay. And the recreation area was like nobody really wanted to play with her. She was shunned, stigmatized. Have we made any progress in that area, or are we still faced with a lot of overt discrimination like that?
We have made...
In particular in the elder area, in nursing facilities, in homeless shelters, et cetera.
We have made some progress in those areas, in part because of policy progress at the state level. We have a couple of states across the country that have enacted laws requiring what we sometimes call cultural competency training, to train provider staff in how to address the kinds of situations that you're describing. And we have a growing national program that provides that kind of training in nursing home settings to long-term care providers. So yes, we have made some progress. Having said that, this challenge of discrimination and stigmatization of LGBT older adults in nursing care and long-term care is a profound challenge, and we still have much, much further to go. And in fact, what we're seeing is that upwards of 40% of LGBT older adults hide their sexual orientation, hide their gender identity if they're able, in order to protect themselves from that kind of discrimination. So they're being forced back into the closet late in life. So we're making some progress, but we have much, much further to go, and we need anti-discrimination protections and training to continue to make that progress.
Will the Equality Act help any in regard to some of the funding for some of these services in nursing homes and other social program networks?
The Equality Act will absolutely help because it will prohibit discrimination in public accommodations, which includes long-term care on the basis of sexual orientation and gender identity. So it will provide that regime of legal protections that we need. And then there are other avenues that we can use, like the Older Americans Act, to provide funding and support for related services.
Mr. Adams, do you think that the Equality Act and/or the Title VII cases will help to ease the burdens of some of the issues related to pensions, Social Security, and retirement benefits for same-sex couples?
Well, I think with regard to the Title VII cases, it depends, obviously, on how they're decided by the Supreme Court. What we see when it comes to LGBT older adults is that the cumulative impact of a lifetime of discrimination in employment, in hiring, in compensation, in government-sponsored benefits leads to much higher levels of poverty as people enter their old age. If we receive a decision from the Supreme
But the
Court—
question is, you think that the Equality Act will ensure, help ensure that in a same-sex couple, there won't be any issues about any of the spousal benefits, any of the retirement benefits, and that they'll have greater financial security?
Yes, the Equality Act will absolutely, if enacted, lead to greater financial security for LGBT people in general and LGBT older adults more specifically.
Very quickly,
The gentlelady's time has expired.
do we need to ask the question on the census?
The chair will now recognize the gentlewoman from Massachusetts, Ms. Presley, for 5 minutes.
Thank you, Mr. Chairman, for hosting this critically important, again, historic and timely hearing, and thank you for waving me on to this subcommittee to be a part of this conversation. Our forever oversight chairman, Elijah Cummings, often said that sunlight is the best disinfectant. So I am pleased to see our Financial Services Subcommittee on Oversight shedding light on the continued discrimination and injustices subjected onto our LGBTQIA+ neighbors and community members. I'm proud to say that the Commonwealth is home to the second largest LGBTQ+ community in the nation. And for decades, our Commonwealth has led the way in securing equality and justice for our LGBTQ+ community. In 1989, after a nearly 20-year fight, the Commonwealth became the second state in the nation to pass a law prohibiting discrimination based on sexual orientation in employment, housing, and other public accommodations in 1989. In 2003, we became the first state to legalize same-sex marriage, and while our track record is laudable, disparities persist. 1 in 5 LGBTQ individuals across our country live in poverty. 1 in 3 transgender individuals and cisgender bisexual women are living below the poverty line. LGBTQ youth of color in the greater Boston area are disproportionately more likely to be unemployed. Almost 2/3 of transgender individuals across the Commonwealth report experiencing discrimination in public spaces. So we know these problems are interconnected, and the solution must also operate from a level of intersectionality. In order to address these negative outcomes for one's health, safety, and overall prosperity. Because the quest for equality and justice does not stop at the stroke of a pen and the passage of a bill, it takes continued work to ensure compliance and to hold industry and bad actors accountable when they are breaking the law. This is even more important now as we face an administration set on quite literally terrorizing the LGBTQIA community. So this hearing, again, is timely, and I'm wearing another hat because I also have the honor of vice chairing the Aging and Families Task Force. And so one of my priorities on this task force is to develop policies that are nuanced and that speak to the lived experiences of our seniors, especially those that are sadly recloseting just for the purposes of having housing. So LGBTQ justice is senior justice, and senior issues are LGBTQ issues. In 2012, the Commonwealth's Executive Office of Elder Affairs was the first to designate LGBTQ elders as a population of greatest need under the Older Americans Act. So again, in many ways, the Commonwealth, and representing the Massachusetts 7th, I'm proud to say we are leading, but these inequities and disparities exist and they persist. And we've spoken about the impact of the Equality Act and what that could do. But in an effort to continue to shine some sunlight here on the extent of these injustices, Mr. Adam, thank you so much for speaking to the impact of having fewer assets and less capital and retirement savings, speaking to isolation, limited opportunities for long-term care and senior housing. But I just want us to speak, and Ms. Tobin, if you would, more to the social impact of this. This is traumatic. The community is being terrorized. And so, I hope that the Senate will do their job and will continue to organize to unfortunately have to force their hand to do that. But if you could just speak more to the confluence of all those many hurts, what is this impact?
Well, Congresswoman, it will take years, I think, to understand the true scope of the harms done by the government's turning on a vulnerable minority of Americans, and in fact, of course, many vulnerable minorities of Americans in this way. We know even the FBI's woefully incomplete hate crime statistics have been spiking. We know that we hear from more and more parents and families and students around the country all the time who are scared because the atmosphere created by this, the president didn't create this kind of hate, but he does seem to be feeding it every day. And, that it's very scary for families that we hear about every day. We already see many transgender people, as I've said, who are homeless and afraid to seek shelter, and the kinds of steps that HUD is taking could further deter people and leave them out on the streets vulnerable to violence. We're aware already of many cases of transgender people, transgender women on the street being targeted for violence. So it's very serious.
That's my time. I hope there'll be a second round. Thank you.
Gentlelady's
Thank you for being
time
here.
has expired. The gentlewoman from Virginia, Ms. Wexton, is recognized for 5 minutes.
Thank you, Mr. Chairman, for yielding, and I thank you also for holding this very important hearing, and thank you to the witnesses for appearing today. As a few of you have already mentioned in your testimonies, HUD Secretary Ben Carson testified here before this committee in May, indicating that the agency was not considering revising the Equal Access Rule. In fact, he unequivocally told me on the record, "I'm not currently anticipating changing the rule." But the very next day, HUD released a proposed rule that would roll back the Equal Access Rule's essential anti-discrimination protections for transgender people experiencing homelessness. The Equal Access Rule protections are critical because they ensure that transgender people can access HUD-funded shelter consistent with their gender identity. There's a lot of misinformation out there, and I think it's important that the public understand the implications that rolling back these critical protections would have on the transgender community. Ms. Tobin, how were transgender people seeking safe shelter treated before the Equal Access Rule was put in place?
Well, as I said, Congresswoman, our research and that discussed by the other witnesses has found discrimination, both staggering levels of homelessness among the population, so the need is extraordinary, and widespread discrimination in shelter access. We certainly have seen through the efforts of state and local communities and leaders in the field, together with the Equal Access Rule, has helped quite a bit. And we do think that most programs today are moving solidly in direction of welcoming people without discrimination, which is why it's all the more important that we not go backwards when the risks that people face being put out on the street are so serious.
And following up on that, I know that that you had talked a little bit earlier about how housing transgender people according to their gender identity does not endanger the safety of others. How about privacy? That's something I know that Secretary Carson, you may remember, he said that's something about big hairy men, being threatening or invading the privacy of women in shelters. Can you explain whether this is founded or what you have found with regard to privacy?
Well, I'm glad you asked. The Equal Access Rule actually requires shelters to have policies and procedures and to respond to any privacy concern raised by any resident. And that's, in my experience, what shelters do. And it's because of that the National Task Force to End Sexual and Domestic Violence has strongly supported these protections. Shelter providers have found that this is absolutely not an issue. In fact, when I was at a community forum you held, Congresswoman, some months ago, we spoke with a woman there from down in Winchester who said, she had been turned away at one point from a women's shelter, forced to stay as the only woman in a men's shelter, where she was a target for sexual harassment because she so obviously stuck out. Later was welcomed into a women's shelter and said the only time that being transgender even came up during the time she stayed there, sharing a room with several other women, was when several of the other women that she had met and befriended there said to her that they were inspired by getting to know her and that she was persevering in the face of all the same struggles that they all faced with homelessness and dealing with the stigma of being transgender on top of that they found that inspiring. And that was the only way that her being transgender even came up, staying in a women's shelter and sharing a room together. So that's very much reflective of what we hear from across the country.
Now, HUD also announced changes to its Continuum of Care program in its 2019 Notice of Funding Availability, or NOFA. The 2019 NOFA removes all prior mentions of LGBTQ people, including incentives to promote effective services to transgender people experiencing homelessness. It also removes any mention of the 2016 Equal Access Rule. Ms. Tobin, can you explain how these changes to the NOFA affect transgender people experiencing homelessness?
Well, this is part of a pattern even before HUD revealed its plan to roll back the rule, to gut it, to pull back everything, guidance, notices, everything that informs providers and shelter seekers about the rule and their rights and helps people understand how to implement it. And in essence, it gives a green light to discrimination. Now, I don't think most providers, fortunately, are going to take them up on that, but some will, and that really means people could be, out in the cold and facing a lot of risks, which is exactly what HUD's programs have been established by Congress to prevent.
Thank you very much. I'll yield back.
The gentlelady yields back. The chair recognizes the gentlewoman from Michigan, Ms. Tlaib, for 5 minutes.
Thank you, Mr. Chairman. Thank you all so much for being here. The Detroit Free Press published a story about a local resident who is transgender. In 2015, Amani Love, a 22-year-old outreach coordinator and worker at a program for homeless and disenfranchised LGBTQ youth, legally changed her name. And she was able to get the new name on her state ID. However, the clerk refused to change the gender. Over the years, the state of Michigan's refusal to issue her correct ID has led to numerous humiliating and uncomfortable situations. Imani's story is like other individuals in the trans community nationwide. The transgender community not only has to go through difficulty of discrimination and violence before, during, and after transitioning, but they also face discrimination from their employers and from their communities, as you all know. Worse, they face challenges from the government that is tasked with protecting them by having them to fight for legal documentation that reflects their gender and name. A basic right and dignity that gender individuals are granted every day. Question for Ms. Tobin, can you talk about those kinds of challenges as well as associated with costs and processes the transgender community faces when making gender and name changes on legal documentation?
I'm glad you asked that, Congresswoman. Transgender people do face many challenges. We all increasingly have to use, ID every day for all sorts of things, including accessing housing, employment, healthcare, and services. And for trans people who can't easily get those documents updated and accurate, it can expose them to discrimination, harassment, all manner of problems. States are across the country making rapid progress in improving those procedures. But there are still significant barriers. And one of the problems with HUD's proposal to gut the Equal Access Rule is that it would actually go exactly the opposite direction of the Housing First approach that experts in the field support, and HUD has until recently supported, by encouraging shelters to adopt strict requirements about ID and scrutinizing whether people's ID matches their gender presentation and so forth. That would just increase barriers to shelter, not just for a minority of people who are at increased risk and need, but really for everyone. We should be reducing barriers to accessing emergency shelter, not increasing them.
And Mr. David, what role does proper legal identification play in the process of finding safe housing?
Well, unfortunately, as Ms. Tobin mentioned, it's become a huge problem. Many members of the transgender community face additional obstacles simply getting access to housing, whether it be transitional housing or permanent housing. And if you're seeking to apply for a mortgage or you're going through the lending process and you're vital documents do not actually correspond to your gender expression, you face additional obstacles, which is one of the reasons why we're pushing so hard to pass the Equality Act. We need to make sure we enshrine those protections in statute. We do have some protections through judicial decisions, but we don't have them in statute on the federal level. But members of our transgender community, because in some states, they do not allow transgender members to change their vital documents because they don't recognize their gender identity and expression. And that's an additional obstacle that they have to face.
And, I represent the third poorest congressional district in the country, and nearly a third of the transgender people in Michigan, 30%, are living in poverty. And we continually talk about, economic opportunities, jobs, and so forth to try to combat poverty. And I don't know, Ms. Tobin or Mr. David, if you can talk a little bit about, because one of the things that I did is we reached out to a center that helps a lot of my youth through the transition, trying to create care. And it always comes down to the stuff that we don't talk about enough here, which is the documentation that helps and give us a role as government to allowing easy access to that, right? I mean, pretty simple. And so I want to talk about how, for me as a member of Congress, how am I able to really combat poverty in the transgender community if I can't even get them the documentation that they need?
The gentlelady's time has expired. We will have a second round, and you'll be permitted to take up your question in the second round. At this time, the chair will recognize himself for 5 minutes. Is it fair to say that market-based solutions will not prevent the invidious discrimination that is continuing currently? If you agree, would you kindly raise your hand that market-based solutions will not prevent the invidious discrimination that's occurring now? All right, all hands have been raised. Let the record so reflect. Is it fair to say that credit reports do not prevent intentional invidious discrimination? Credit reports do not prevent it. If you agree, would you raise your hands? A credit report. Let the record reflect that all hands have been raised. I'm doing this because invidious discrimination is irrational. It makes no sense. And because it makes no sense, you can't prevent it with something as simple as a credit report, because people do it with intentionality. There are people who don't like us because they don't like the way we look, in my case, or because they perceive a person to be of a certain sex. It's irrational. And that kind of irrationality has to be circumvented with more than legislation that provides a civil remedy. Going to court is a great remedy if you have the money, if you have the lawyers, if you can perfect litigation that can be efficacious. It is my belief that we need criminal penalties. People who steal money from you at the bank can suffer from criminal penalties. Penalties associated with fines and time in jail. I don't want to manage invidious discrimination. I want to end it. And one of the best ways to end it is with legislation that will penalize people who intentionally, who knowingly discriminate against persons and do so currently with a certain degree of impunity. So I have a bill, H.R. 166, the Fair Lending for All Act. This legislation carries with it penalties, fines, so that persons who intentionally, knowingly discriminate, they will suffer more than some civil penalty leveled against the institution. People who discriminate have to be called out. They have to be dealt with. It's time for us to move to the next level in this fight. And the next level includes criminal penalties for stealing, for the theft of my opportunity to have a loan. This is more than simply a slap on the wrist, and I understand it. But we have to do it because, quite frankly, lending institutions, they sort of ignore these laws, and people are finding themselves having to come out of pocket with huge sums of money to fight this invidious discrimination. So I want you to take a look at my bill, H.R. 166, and if you would, send back to me your comments on H.R. 166 in terms of how you think it can impact what we're trying to accomplish with invidious discrimination. I'm also going to, because of the landmark nature of this hearing and the empirical evidence that's been presented, I'm going to place all of your statements, not only in this record, they will be in this record, of course, but I want to place them on my website. I want people to have access to what you've said. The evidence is unbelievably overwhelming, and we ought not just have a hearing today and let this be the end of it. This information has to be received and transmitted across the length and breadth of the country so that people will understand that what we're dealing with is real and that people are being impacted on a daily basis by this level of invidious discrimination. I will place it on my website at algreen.house.gov, and persons can go to that website and you'll find all of these statements, algreen.house.gov. With this said, I'm going to yield back the balance of my time and recognize the gentlelady from Texas, Ms. Garcia, for an additional 5 minutes.
Thank you, Mr. Chairman. Thank you for the opportunity to ask two more questions that I had that, because of time in the first one, I couldn't do. I'm going to ask Ms. Conrad and Ms. Professor Sun the question about the census. Do you think that it would be helpful, and for what reasons, and what areas would it be helpful to get a question on sexual orientation or gender identity on the census?
Thank you for the question. It would be unbelievably helpful to get questions about sexual orientation, gender identity, and assigned sex at birth on the U.S. Census, as well as other surveys that are managed by the Census Bureau, like the American Community Survey, the Current Population Survey, the surveys about housing, and so on and so forth. These surveys are critical sources of information about socioeconomic status. They provide information about housing, information about employment, occupation, income, wages, and they really are critical for monitoring discrimination against people on the basis of all sociodemographic characteristics. So it would be a tremendous help to get these questions on the surveys. And frankly, it's a long time coming. We have about 20 years experience collecting these data, and there really is no reason not to put these items on the census and these other surveys at this point in time. Thank you.
Professor?
Thank you. I agree with Dr. Conran that I think census definitely should collect more information in this regard. Although they have started collecting some of the information since 1990, so they provide some like the percentage of same-sex population at the neighborhood level up to the like zip code or block level. But certainly more information, more detailed information in terms of demographics of same-sex people will be very beneficial.
Right. And Mr. David, with regard to this topic, it would take more than just the Equality Act or any of the Title VII cases in process. It would take action from Congress.
Correct. Additional action from Congress to ensure that this information is actually enshrined in the census.
Right. Have you all met with or visited with the Census Bureau folks on this issue?
I have had conversations with the Census Bureau on this issue in the past. I don't know whether or not their views have changed. Their initial views were not accommodating, probably the best word to use, but we will continue to have those conversations.
Right. Ms. Tobin, I wanted to follow up on some of the questions that Mr. Lee brought up with regard to the data in getting your birth certificate change for the gender marker. This is not only, troublesome in many states, and I know in Texas it is not only troublesome, it's burdensome. You've got to go to court, you've got to have an affidavit from a doctor, it's a long process. And in fact, it's so troublesome that in Harris County, my home county and the home county of the chair of the subcommittee, there was no judge before this last election, no judge that even wanted to take up the gender change, because it requires a court hearing. They didn't want to hear them, so people had to travel all the way to Austin to do it. Could you just crystallize for us the average time, the process that goes through? Because there really are some people that think that we can sit here today and just decide overnight that we're going to change. And, for example, I would change and decide I'm going to be a man beginning tomorrow, and the chairman would decide he was going to be a woman tomorrow. It's not that simple, is it?
Well, Congresswoman, the procedures for name and gender changes on ID and birth certificates vary a great deal from state to state. These things are managed at the state level. There's a tremendous amount of reform and improvement happening, but it is a process that can take many weeks or months in some jurisdictions. Even in jurisdictions that have streamlined that process a great deal, individuals do have to sign a statement stating under penalty of law that they're undertaking that change for purposes of being consistent with their gender identity and not for any other purpose. States have found that requirement to be sufficient to serve all of their official needs. That's been very successful across the country, but even then, it can be a costly and time-consuming process, which is why it's important that for federal programs that we not tie eligibility and access to critical services, especially things like emergency shelter, to things like ID document gender changes that can be so variable and burdensome to get across the country.
Thank you.
Gentlelady's time has
Yield back.
expired. The chair now recognizes the gentlewoman from Michigan, Ms. Tlaib, for 5 minutes.
Thank you, Mr. Chairman. I know we left off, one of the things I think folks don't understand is, being poor you can die from being poor. It kills. Poverty in our country kills. Maybe not getting access to clean drinking water, a home, food, whatever it is, healthcare. And so, it is important for me as I'm trying to combat poverty and with all of my residents, it always starts with this documentation and getting this information in their hands so they can apply for the help, so they can seek it out. And so if you can continue the conversation we started about that, I just want a lot of the neighbors and folks to fully understand it isn't even the transitioning and everything that happens, the impact on their, especially my transgender neighbors in that process, that it's even not only discrimination and violence, horrible violence, but it's also the own government not making it easy on them. And that is something that I wanted to highlight here.
Sure. I think putting it in context for people is critically important. If you don't have the appropriate documentation, you can't get into a government building. You may not be able to get onto an airplane. But when we're talking about basic necessities, getting a job, getting a home, getting access to certain types of public accommodations, if you don't have vital documentation that's consistent with your gender identity, it makes it very, very difficult to talk about getting out of poverty. And many members of our transgender community face additional challenges. So coming out as transgender, and we talked about, well, we actually didn't talk about that specifically here, but the suicide rate, as an example, among Black transgender women is 47%. 47% of Black transgender people attempt suicide at some point in their life because of all of the challenges that they face. So without this vital document, whether it be a driver's license or a passport or some type of documentation, it makes it very difficult to get out of poverty, it makes it very difficult to get and sustain a job, makes it very difficult to obtain housing. And so one of the tools that I think is incredibly important for legislators to think about is creating solutions at the state level as we continue to fight to pass the Equality Act, because many members of the transgender community need those changes now. So in order for them to get the job and the housing, we need the state protections. So, Ms. Tobing, I don't know if there's more you want to add to that.
Well, you've stated it very well. There certainly are still some states in which you have to pay high fees, wait many months to go to court. There's a small and shrinking, but still a number of states that require you to show proof of medical procedures that might even be medically contraindicated for you, without which you can't obtain appropriate documentation, and you could have exactly all of the barriers to opportunity that Mr. David outlined. And so it's definitely important that we pass the Equality Act at the federal level, and that we work at the state level to continue to make accurate ID available to everyone.
Thank you, Ms. Tobin, and thank you, Mr. David. I yield the rest of my time, Mr. Chairman.
Gentlelady yields. The chair now recognizes the gentlewoman from Massachusetts, Ms. Presley, for 5 minutes.
Thank you, Mr. Chair. I know it is off topic, not germane to the subject for today, but I'd be remiss if I didn't just offer to all of you, and I would love to enlist you as accomplices in this work. I support the Dignity for Incarcerated Women Act. And given the confluence of all of the intersectionality of both oppression and trauma and discrimination here, we know that so many transgender individuals are, have no other choice but to do sex work. I'm for decarceration, but while folks are incarcerated, we need to make sure they're treated with dignity and that they're safe. And so I hope that some of you would be willing to work with me on those protections and those issues specifically. And as I mentioned earlier, vice chairing the task force on aging and families, these specific nuanced issues facing our LGBTQ+I elders. But my question, Mr. Creighton, was actually on the consumer reporting side of things. I'm a firm believer in data. The best policies are informed by data. That data, to me, are the lived experiences of people. I also believe that which gets measured gets done. So we need that reporting for the purposes of transparency and accountability. Your organization prides itself as being the voice of the consumer reporting industry. So how can an eviction be reflected on an individual's credit report or rental history report?
Right now, we don't collect that information because it's not predictive in whether or not somebody is going to pay back a loan. And we would suggest that there's nothing in the gender identity or sexual orientation of an individual that would be predictive for a loan. And so we wouldn't collect it. Our business is in credit reporting.
I see. Okay. So does the eviction information specify whether discrimination played a role in the eviction?
Eviction records are what they are. We're just passing on the eviction records that we get from other places in consumer reports. Of course, eviction is not part of a credit report. It's part of the other kind of consumer reports.
And do you believe the lack of information about discrimination in rental history reports puts LGBTQ+ individuals at a further disadvantage while seeking rental housing?
I don't know the answer to that.
Any other opinion you'd like to elaborate on where that is concerned?
Eviction records are important for landlords to consider when they're looking to rent an apartment to somebody, and it's one of many factors that they're going to take into account. It shouldn't be the determinative factor, but it should be a factor. And eviction records are public records, and so we help landlords get access to them.
Okay. Anyone else on the panel care to comment?
I just want to add that when we try to merge the HMDA data with the Fannie Mae single-family loan performance data, we do find that there is some evidence that same-sex couples are less likely to prepay their mortgage. In terms of default risk, there's no prediction power in terms of that, whether they're more likely or less likely. They are equally likely to default on the loan, but in terms of the prepayment risk, that's still a legitimate risk factor to lenders. There's a prediction power that same-sex couples turn out to be less likely to prepay for their loan. So there is some chance that it might have some prediction power in terms of the overall credit risk assessment.
Thank you, Professor Sun. Anyone else? We've got about a minute 19 left here.
I would just add that I think that there's ample evidence that the failure to ask for data on sexual orientation and gender identity, in fact, contributes to discrimination and marginalization, and we need to look no further than the Trump administration's efforts to remove those questions from the National Survey of Older Americans Act participants in 2017. In fact, when those questions and when that data was being collected, what it demonstrated was the failure for federally funded elder services to arrive at and be received by LGBT older adults. If we stop asking those questions, we don't identify that problem of discrimination and access.
Right.
And I'll also say that although the data may not be collected in the form that we want now, we do know that in the mortgage and lending industry, same-sex couples are facing discrimination. If you receive a lending application or a mortgage application from Ben and Peter, as opposed to Ben and Susan, we know that that application is being treated differently. And we know from our history, we know from redlining, we know from mortgage-backed securities that the financial sector has unfortunately treated racial minorities, disadvantaged groups differently. And unfortunately, it's the same here for same-sex couples and members of the LGBTQ community.
Thank you. Thank you, panel.
Gentlelady's time has expired. The chair recognizes himself for a final 5 minutes. Let's continue where you were leaving off, Mr. David. Give other examples of how the loan officer can ascertain that the person is a member of the LGBTQ community who is the borrower.
So in addition to the mortgage application, which would reflect the names of the parties seeking the mortgage, in some cases there may be an interview where the parties will show up to talk about their interest in purchasing a home. And at that point, they identify their relationships. In other instances, they indicate that they're married on the application itself, and they indicate the person to whom they're married to. And under all of those circumstances, the financial institution will have information with respect to the sexual orientation of the party seeking to purchase the loan or seeking to enter into some type of financial transaction with the institution.
Let's move to the area of housing. How have we been able to ascertain that the discrimination exists with same-sex couples? Perhaps testing might be a part of the answer. Would someone care to respond? Mr. Adams?
Yes, thank you. We have good beginner data on that question because of research that has included testing-based research. The study that I referred to previously that documents discrimination at the level of 48% against older same-sex couples is testing-based discrimination in which different sex couples and same-sex couples were applied for senior rental housing. That kind of testing can ferret out discrimination and identify where we need to take action. And I might add that studies like that demonstrate that market incentives are not enough to eliminate discrimination. There are plenty of market incentives in senior rental housing, and we still see very high levels of discrimination.
Thank you. I'm going to conclude with some statements. I think this hearing has been exceedingly important because we have legitimized data. We've legitimized the fact that this invidious discrimination occurs. It's important for us to first recognize that the problem exists if we're going to do something about it. For too long, people would simply ignore the facts, not have to do something because there was no harm taking place because it was being ignored, or saying some people would simply say, well, it's just not true. People don't discriminate against gay people. But today, we have demonstrated with empirical evidence that this level of invidious discrimination exists, such that it is quite harmful not only to the persons who are being discriminated against, but also to the country. Because I have some evidence here indicating that the community, the LGBTQ plus community, consists of persons numbering in the millions, approximately 16 million, I believe is the number that I have, and that we have $1 trillion worth of buying power within the LGBTQ plus community. So it makes no sense for us to discriminate because we're hurting ourselves when we do this. But it does happen. We've legitimized it, the discrimination exists. And I would add this, there are people who believe that we should approach these problems with each community acting on its own. I'm not one of them. I think that as an ally of the LGBTQ community, not a member of it, but I have a duty to do all that I can to prevent the discrimination. But I shouldn't be alone. I think that when it comes to discrimination against African Americans, then I should have the support of the LGBTQ plus community. And when it comes to discrimination against Asian Americans, we should support the effort to end that discrimination. We cannot silo ourselves and deal with these problems in an effective way. We have to deal with them in concert with each other. And we have to be bold enough and brave enough to tell people within our own communities that we have to reach across the chasm to persons in the other communities so that we may work together. It is with this strength that we can not only manage but eliminate these problems. I started this hearing by indicating that you're not alone. I end, you are not alone. You have allies within this Congress who are going to fight with you and for you. I'd like to thank the witnesses for their testimony and for devoting the time and resources to travel here and share their expertise with this subcommittee. Your testimony today has helped to advance the important work of this subcommittee and of the United States Congress. The chair notes that some members may have additional questions for this panel, which they may wish to submit in writing. Without objection, the hearing record will remain open for 5 legislative days for members to submit written questions to these witnesses and to place their responses in the record. Also, without objection, members will have 5 legislative days to submit extraneous materials to the chair for inclusion in the record. Without objection, the hearing is now adjourned.